Hey, Craig Powers, Powers Firearms Training here. Thought I'd give you a little update on the new laws that go into effect the 1st of January 2019. So they've been in effect, a few days now. There's also some laws from before that go into effect, and I just wanted to cover them with you just kind of briefly. The first one is AB 1192, just changes the way certain retired peace officers are handled under the firearms laws. It's not a big deal. The unsafe handgun bills, AB 1872, AB 1872, just exempts certain agencies and their active duty peace officers to the unsafe handgun bill, except the guns are not actually unsafe. They're not unsafe. So the guns that are not unsafe to be sold in the state of California, they're not unsafe guns. They're not unsafe to be sold. That would be the list. People who are exempted from that list include certain peace officers, and AB 1872 now defines Harbor Patrol and Port Authority police officers. They're exempt from that list. So AB 1968 has to do with mental health and firearms prohibitions. And beginning January 1, 2020, this bill imposes a lifetime prohibition, a lifetime taking away of your Second Amendment rights if you've been taken into custody, assessed, and admitted to a designated facility twice in 1 year because you're a danger to self or others as a result of a mental health disorder. Well, what does that mean? I mean, I'm a licensed marriage family therapist. The one thing that therapists are consistent about is that the only thing that's absolute is that it all depends. So what does that mean to people who had maybe a horrific death in the family, they're having trouble dealing, they get through it, but they end up with a couple of hospitalizations in a year? Well, that means they lose their right to own a gun for the rest of their life. So just need to be aware of it. However, every 5 years, those people can go to the court and ask the court to restore their rights. A lot of people who are mentally ill are not a danger to anybody but themselves. And granted, we don't want people who are a danger to themselves to kill themselves, and there are steps we could take as family members and friends to help those people, we should. But a lifetime prohibition? It's a little concerning, but it's the law, and we live in the state of California, and that's where we are. AB 1993 has to do with a dealer who takes a gun in on consignment, essentially what used to be like a pawn, where they would pawn it, except for in pawn shops fall under this. But before, they had to wait 30 days to make sure the gun wasn't stolen before they could put it for sale. And Bill 1993 holds it to a 7-day period in certain circumstances, a 5-day period, except for firearms. Firearms still have to be held for 30 days, just to slow down the whole report of acquisition and so that the dealer can sell it. I don't even know what the logic is on that. Okay, AB 2103, which is what those of us who have concealed weapons permits and our company is concerned about, has to do with license to carry a concealed weapon. And AB 2103 says that training to get your permit, your concealed weapons permit for the first time, can now be no less than 8 hours. Now, we've always, as Powers Firearms Training and Powers Security Training before that, always done an 8-hour class for an initial CCW class, but now it formalizes it. And it adds that when you get your permit for the first time, any guns you want to put on your permit have to be shot and you have to qualify with at the time of class. So you have to have actual live fire for the class, which is what we always did. The change being you have to shoot every serial numbered gun for qualification. So if you're going to put 10 guns on your Kern County Sheriff's permit, you have to shoot all 10 guns with the Kern County Sheriff's qualification. And AB 2103 also requires the Kern County Sheriff, for instance, or BPD or Delano PD, to develop a policy and a qualification regarding what they find is acceptable, and then publish that. So we're going to be talking about that in a separate video, but the Kern County Sheriff is like 10 rounds. No, wait, that's not Kern County. It's 12 rounds. I think Delano was 10 rounds. No, that would be Tulare County. No, are you confused? Well, most of us are confused because we still don't have reports from everybody as to what that means. So we're working on it, and hopefully it'll get clarified in the next couple of weeks. AB 2176 requires that when they seize your gun, the police, because somebody has filed a domestic violence gun restraining order, because they've alleged you've committed domestic violence and you're getting a gun restraining order, they can now seize your ammunition and your magazines along with the guns. But that the officer has to give you a receipt for your real property, because evidently that part of the Constitution still survives in the state of California, but don't hold your breath. AB 2222 just settles that firearms that are stolen or found or recovered, held for safekeeping, held on a gun violence restraining order, all have to be entered into a system called the Automated Firearms System, generically referred to as AFIS, within 7 days of their receipt. So they have to enter it in. That way, if your gun gets picked up, it got stolen and it gets picked up 3 months later in Delano or Sacramento, then they have to go check to see if it's stolen within 7 days of receipt. I pretty much support it. I don't know if there's any downside to that. And it also requires stats to be kept that if the gun's actually been used in a crime, that has to be notated so they can keep better records. And then it defines who a law enforcement agency is when they seize it. AB 2526, again, is about temporary emergency gun violence restraining orders, and it allows a judicial officer to issue one, a temporary one, and any police officer who requests a temporary emergency gun violence restraining order, they have to actually sign a declaration under penalty of perjury, so that if they lie, they can be held responsible, reciting their oral statements provided to the judicial officer, and then that gets memorialized, in other words, written in stone to the court, if it's made orally. It's just a little tweak to the current law. AB 2930 regards unlawful detainer, nuisance, unlawful weapons and ammunition. What's that? Well, it extends the authority to police officers in the state of California until January 1, 2024 for 2 nuisance eviction pilot programs that conditionally allow city attorneys and prosecutors in authorized cities to bring eviction proceedings against tenants for committing nuisance violations involving unlawful weapons and controlled substances. So it allows the city attorney to have you evicted from certain properties in certain states or cities in the state of California because you own guns or because you're operating a drug house. And I can see that part of it, I guess. But we've had instances of people being evicted from public housing because they actually owned a firearm and somebody found out about it, legally owned it. So it's a bit of a concern. SB 746 authorizes a person who is temporarily prohibited from owning guns or ammunition or magazines under the new domestic violence gun restraining order to temporarily give that to a dealer for the duration of their prohibition period when they can't own guns, and also requires somebody who moves into the state within 60 days of their arrival and they own, say, a AR-15 or a handgun that they built and it is not serialized, that they have 60 days to request a unique serial number and put that on the gun. And July 1, 2020 makes the procedure for a court or law enforcement agency to return a seized firearm also applicable to ammunition and magazines they've seized. And That's that section. AB 1100 regards firearms and transfers of firearms. And it prohibits anybody under the age of 21, except as exempted, from receiving a firearm that is not a handgun to somebody who's 18 years of age but under 21. And the exceptions to those would be people who have a valid hunting license. So if you were 19 years old and had a valid hunting license, you could receive a shotgun or rifle. And active duty peace officers, of course, they're exempt because, that's what we do. And active federal law enforcement people and reserve peace officers and National Guard, people who are 19 or 20, they can receive guns. And that anybody who wants to manufacture their own gun, which is, the AR-15's like, they call them a Barbie gun because you can dress it up any way you want. And one of the things you can do is buy a frame and mill the frame out yourself. And the frame can be no more than 80% built under federal law. And then you can make your own gun. You assemble it. And sometimes they don't work very well. Sometimes they work great. But it's legal under federal firearms laws. Except you'd be illegal to own an AR-15 in America, but in California, if you're 18 and you want an AR-15, you can't transfer one to you because California. So SB, Senate Bill 1200, just adds ammunition and magazines to the gun violence restraining order and requires a police officer who's executing a gun violence restraining order to ask about ammunition and magazines, and requires the court who issues a temporary gun violence restraining order to have a hearing within 21 days to see if it's going to be lawful. SB 1346 clarifies the definition of a multi-burst trigger activator to include a bump stock, bump fire stock, or similar devices. So I guess it now bans your finger from bump stocking. I don't know. But anyway, the stock is now illegal in California. SB 1382 is actually a really good bill. It just clarifies that if you have a truck with a lockbox in the back, that actually is an enclosed container permanently fixed to the bed of the truck, is lawful for you to store your gun in. So if you leave your gun in an unattended vehicle, but you left it in your toolbox in the back of your truck, or your lockbox in the back of the truck, that's legal. Now, California changed a few years ago so that if you're going to leave a gun in the car unattended, that gun has to be in a locked container secured to the vehicle, or a locked container hidden from view while you're away from the vehicle. And if it's not, you're culpable. And I think even more importantly, it increases your civil liability, because if somebody takes your gun out of the car and goes on a shooting spree with it, you didn't lawfully have the gun in the car, so I think that probably makes you a little bit liable, or it could be. It puts you at risk anyway. Okay, bills that were signed into law in 2016 to go into effect this year, we include AB 857. Just requires that if you're going to build your own gun, DIY your gun, that gun has to have a unique identifying serial number issued by the state of California, and then you have to register it with the ATF apparently. And SB 1235 is the ammunition ban, along with Prop 63, which goes into effect. And starting July 1, when you buy ammunition, you have to go through a background check to buy the ammunition. And the gun store is allowed to charge you a $1 transaction fee. Or it could be like the liquor store or the local bait shop. They can charge you $1 to transfer ammunition to you, and they have to go through a background check at the time they do that. The DOJ doesn't have their regulations. Had 2 years to do it, 3 years actually almost, and they've not drafted their regulations regarding ammunition. So we don't know what that's going to look like. So there's a bunch of lawsuits on the ammunition stuff. There's lawsuits actually on all of it, and yet under the Ninth Circuit Court of Appeals, we don't have the right to own guns in the state of California because it can be infringed, and it has been. So there's currently a case pending acceptance by the United States Supreme Court. The fact that we have a new Supreme Court justice makes it pretty possible that they'll accept it. And if they do, then there's a possibility we can have our right to own guns and ammunition in the state of California restored. So basically, they don't have the right to completely ban guns, but the handgun list, for instance, that you have to buy a gun that's on the list, has reduced the guns to, and I don't even know the exact number, but it's probably no more than a third of the guns that you could legally sell in California before that. And probably a quarter or a fifth of the guns that you can legally buy in America, you can't legally buy in California. So look at Second Amendment Foundation, look at firearms. I'm going to forget. It's the CalGuns organization and some of the other organizations that are suing. If you're looking for who to donate to, there's no big giant rich guy out there funding, supporting your civil rights. The NRA only picks cases they think they can win at, so which kind of I guess makes sense. But that's where we're at with it. So if you have any questions, email us, and the link's in the description below. KernCCW.com. You can go to info@kernccw.com or craig@kernccw.com, and we'd love to hear from you. So that's the law update. Hopefully this has been helpful, and if not, then make a comment. So love to hear from you. Have a nice day. Go out to the range and shoot your gun.